Hey, AP Government, welcome into your weekly address for this September 15th. Tomorrow, I talked about how we're going to celebrate Constitution Day with a fun activity. So I felt like I just would bring you up to speed a little bit more about the powers under the Article 3 of the Constitution in dealing with the Supreme Court and the federal courts as well. I'm going to go right away back to the system of court structure we were talking about as we wrapped up class today. And so you'll see that chart that I promised here coming up on the screen shortly. Essentially, what I really wanted to highlight was the fact that the federal court system, which is really outlined in Article 3, is greatly different than the state court system. It's a wonderful example of federalism at play within the Constitution. The state governments have their own courts, their own local courts, their own appeal courts, and their own even Supreme Courts for each state, whereas the federal government has its court system, starting with the district courts or the circuit courts, and then that works its way up to the appellate courts or Court of Appeals before a case can then make its way to the Supreme Court. You know, the statistics there are 94 district courts, 13 appellate courts, and 1 Supreme Court. That's great if you guys can remember those. But the principle here at play is, again, a very important legacy within the Constitution of federalism. The federal government only has jurisdiction, the judicial branch, I should say, only has jurisdiction over federal courts. The Supreme Court cannot overrule a ruling in the state courts unless that state court ruling makes its way up to the Supreme Court. And that can happen. The same goes for other courts like bankruptcy courts, which are another form of the court system, the federal court system. But traditionally, for a case to make itself go all the way to the Supreme Court, you essentially have to lose cases in order to appeal. So the cases that go to the Supreme Court are typically, almost all exclusively, appeal cases that have worked their way up from district courts to appellate courts and then eventually to the Supreme Court. I mentioned in class how 4 of the 9 justices must agree to hear a case before it actually even reaches the Supreme Court. So for a case to get to the Supreme Court, it's actually really rare. This doesn't happen all the time. And the nuances of the cases, I wouldn't say you need to know exactly the procedures for the cases themselves, but when we talk about specific Supreme Court cases later this year, we'll certainly get into that. Now, to recap a little bit again, selection for federal judges at the lower levels and the Supreme Court, the president typically nominates federal judges, and that has to be confirmed by the Senate. However, Congress has the authority, Congress is empowered to manage and create and modify, if needed, the lower circuit courts. So that is up to Congress. Now, who checks the Supreme Court? Well, that's a very important question, and that's one that I hope to get into on the rest of this weekly address. The president nominates the justices. So in theory, the president has control as to who is, at least in part, selected to receive a potential seat on the bench of the Supreme Court. However, it's the Senate that must confirm. So you see, both the president and the Senate in that respect have a check and balance over the Supreme Court. But when the Supreme Court issues a ruling, who checks that? That's a very important question. And that leads us back to the all-important case of Marbury versus Madison from 1803. To understand the importance of Marbury versus Madison, first think of the context. This is a case that has long-standing impact on the entire American government. Marbury versus Madison was one of the first Supreme Court cases that announced the principle that the Supreme Court can declare an act of Congress void if it is inconsistent with the Constitution. Again, what that means is, ultimately, Marbury versus Madison, the ruling, allowed for the Supreme Court to declare laws passed by Congress unconstitutional. The principle that you want to get down in your notes as you're watching is judicial review. That is the principle that is essentially established here with the Marbury versus Madison ruling. Judicial review. The power of the Supreme Court to interpret the law, to carry out Article 3 and all the powers that are present. So how do we get here? How does this judicial review process begin, and what in fact was the case? I wanted to first make sure you're aware of judicial review. That is a key term to always associate with Marbury versus Madison. So here's the deal. When John Adams was leaving office in 1801, March 4th, of course, was the old inauguration day, Adams would turn over the government to Thomas Jefferson, who had won that crazy and wacky election of 1800. One of the last measures of Adams's presidencies is that he appointed 17 federal judges, one of the powers, of course, of the executive branch. And Adams did this at the very last possible minute, which is why these 17 are formally known as the Midnight Judges, because Adams did it so close to midnight before his time as president was up. There's nothing wrong with Adams nominating 17 federal judges, including one of the judges would be John Marshall, the Supreme Court Chief Justice that we'll be talking about later with this case. There's nothing wrong with what Adams did. That was all within his power. However, when Jefferson took over, Jefferson had his Secretary of State, James Madison. Madison was supposed to deliver these nominations to the Senate. But, given their political beef, Jefferson was not a big fan of the Federalist Party, which Adams had been a part of. So Madison sort of takes his sweet old time, and he doesn't deliver the nominations, all of them at least, to the Senate. So this is kind of like a political issue here. Madison and Jefferson were part of the Democrat Republicans, a political group that challenged the Federalists. And we'll be talking a lot more about political groups later on. But here's what you really need to know about the case. William Marbury, one of those judges who was appointed, in fact, he was appointed to be Justice of the Peace for the District of Columbia. William Marbury's nomination was not going through. So Marbury sued. He sued, essentially, James Madison because Madison had failed to deliver Marbury's commission. And this happened with a bunch of other judges as well. It wasn't just William Marbury, but it was absolutely a handful of judges as well. Now, what Marbury petitioned for was essentially what's called, and this is a very important term, a writ of mandamus. A writ of mandamus. A writ of mandamus is a legal document that basically compels, it's a court order, that an inferior government official is ordered to properly fulfill their duties. In other words, Madison was the Secretary of State, right? His duty was to carry out those nominations, to bring them to the Senate. Marbury argued for a writ of mandamus. And what that writ of mandamus states is that Madison had to carry out those orders to deliver the nomination. So that's what Marbury was challenging, and that's what Marbury was suing. He felt that Madison should have had to carry out his orders to deliver the commissionings for the judges. And so therefore he filed for a writ of mandamus that would order Madison to deliver Marbury's nomination. Marbury's lawsuit and his fight for the writ of mandamus made it all the way up to the Supreme Court in 1803. That's where we get to Marbury versus Madison. And who, by the way, was the Chief Justice? Well, it's John Marshall. And ironically, Marshall was one of those 17 midnight judges. But Marshall's nomination had been carried out. So, here's what Marshall and the court unanimously rule. They deny Marbury petition, and they refuse to issue the writ of mandamus. So Marbury loses the case, essentially. And what the court says here, what the Supreme Court rules, is that the Supreme Court does not actually have the power in the Constitution to enforce the writs of mandamus. That was not something that was part of the Supreme Court's power. This is a crucial ruling because it goes back to what I said earlier. By saying that the Supreme Court does not have the power to carry out something that it does not have written in the Constitution, John Marshall essentially establishes this process of judicial review. Because in turn, what Marshall's court ultimately did was that it established the fact that the Supreme Court, evaluates what is legal and what is not legal. So think about it like this. Marshall is saying essentially in his ruling that because the Supreme Court does not have the power to carry out this writ of mandamus that Marbury was petitioning for, he's essentially saying that's not within the power of the Supreme Court. But he's also at the same time defining what the power of the Supreme Court is, which is to interpret the Constitution. Ever since this ruling, it's been the primary duty of the Supreme Court to interpret the Constitution as it applies within the laws, whether those are state laws or those are federal laws. The Supreme Court interprets how laws and how the amendments within the Constitution and the articles of the Constitution, how they all come together. All it took was for one judge to feel like his rights have been violated for the Supreme Court to face its first major test. And Marbury Madison was one of the most important tests of not only the Supreme Court, but the entire system. By denying Marbury the right to receive a writ of mandamus, the Supreme Court essentially empowered itself to become the sole arbiter in matters of interpreting the Constitution. When a Supreme Court ruling, I'll leave you with this thought, and I'm sure there could be questions, and we'll hash this out together. But think about this. Who says a Supreme Court ruling is invalid? It's not Congress, it's not the President, or any member of the executive branch. When a Supreme Court case is handed down, that is it. It stops there. The Supreme Court, thanks to Marbury versus Madison, assigned itself the sole executioner of the law as far as the Constitution is concerned. Now, the President enforces the law. Congress makes the laws. The Supreme Court interprets the law. And that ranges all the way down the court system to the very smallest level of courts. So as a citizen, you may have the right to sue that your rights were violated. And if you sue and you sue and you sue and you get to the Supreme Court, it is up to the Supreme Court to decide whether or not your rights were violated in the Constitution. And so there you have it. I gave you a very compelling story, maybe a little confusing at times, but we'll hash that out together as a group. There's also, I'm going to send a link to a reading on the case so that, maybe that will clear some things up for you. But I hope you guys have enjoyed this weekly address. We'll continue going on forward with the Constitution throughout the year, of course. And in the meantime, just keep thinking of Marbury versus Madison as that all-important case that established judicial review. And so with that, I'll leave you with the good rest of your evening. Go Jets. The Jets are on again tonight, so hopefully we'll have better luck tonight. And as always, I'll just remind you that the past shapes the future. Take care, everybody.